Hello, everyone. My name is Adol Korkor, and I'm the founder and the CEO of the A.B. Korkor Foundation for Mental Health. Our presentation today is part of our podcast series with the purpose of to inform you and educate you about matters that often triggers a lot of anxiety in your life. We hope that this series will continue to enrich you. And to be honest with you, it has enriched me in understanding a lot of what was going on, especially in the areas that are related to legal matters. It's often very confusing for individuals to learn about it and understand it and see how it works. We are so fortunate to have with us today Attorney Terry Campbell. Uh, Attorney Campbell is a founding partner at Moertl, Wilkins and Campbell law firm in Milwaukee, Wisconsin. They specialize in trust and special need trust structure and formation. And he's going to enlighten us about these issues. Terry, it's been a pleasure having you here. It's also a pleasure having you on our foundation board. And I look forward to your presentation.
Thank you very much, Adel. We're going to jump right in. Okay, let's get started. Why is this important? It's important because it affects a lot of people. According to the 2011 report by the World Health Organization, there's 1 billion people with disabilities in the world. And according to the US Census Bureau, 18.7% of the US civilian non-institutionalized population reported a disability. A lot of people are affected by these issues. You know, there really is no one definition that defines special needs. It really refers to what those overall consequences are from a disabling condition and the challenges that that disabling condition often imposes on an individual. And this can be physical, it can be mental, it can be a combination of both. This is now from the estate planning approach, and I unfortunately see this mistake, it happens a lot. Do not disinherit a beneficiary with special needs. That is not necessary, and many people believe you have to, that you cannot leave assets for the benefit of a disabled person. So what often happens is a person will choose maybe a sibling or another family member, and they'll give them an extra share. And so the idea is, well, his brother is going to take care of it. I know it's well intended, and it may very well work in some situations, but there's so many ways it can go wrong. If a family member dies, well, that assets may now go to a spouse or another person that maybe doesn't have the same attachment to that disabled person. If that person gets divorced, those assets may leave the marriage. If that sibling who has been entrusted with the extra share is sued, those assets may go somewhere else other than the intended purpose for that disabled individual. And the bottom line is you don't have to do it. We have special needs trust that can protect that disabled person. It will not interfere or discontinue the person's public benefits. And that is the fear. A special needs person may be receiving SSI or may be receiving Medicaid benefits for insurance. And they're afraid if I leave my son these assets, he's going to be kicked off all of those benefits. And that's just not the case. There are two very distinct types of special needs trust. One is a first party or self-settled trust. And that means it's funded with assets that belong to the disabled beneficiary. Now, that may not be assets that the person has in a bank account, because if they're on SSI, they probably have less than $2,000. But what if they have a car accident and now they get a personal injury award? Or what if somebody just leaves them money in a will outright? Well, that's their money. And if they keep that money, yes, they probably will be kicked off public benefits. So they establish a special needs trust. The benefits will continue, and yet the special needs trust can benefit them. The other type is a third-party special needs trust. So if I have money and I have a disabled son, and I am going to put my money into a trust for the benefit of that son. That's my money. It's a third-party trust. Also, don't get confused by lingo. Special needs is often intertwined with supplemental needs, but the vast majority of these trusts are designed to preserve the benefits that that disabled person is receiving. This actually was specifically authorized by Congress in 1993 by the Omnibus Budget Reconciliation Act. But if you're looking for law, in addition to that, there are other two sources that affect these provisions. One is the Social Security Administration's Program Operations Manual System, which we always call POMS because it's too much of a mouthful. And the other are the state Medicaid manuals. In Wisconsin, that would be what is often referred to as the MEH, the Medicaid Eligibility Handbook. So there are certain requirements that have to be met to ensure that a first-party special needs trust will qualify. It has to be established by an adult who has mental capacity, notwithstanding the disability, or it can be established by a legal guardian, a parent, a grandparent, or a court. Now, beware, Social Security has taken the position that a parent or grandparent may have the legal ability to establish it, but they can't fund it unless they have some sort of independent authority. So they are a court-appointed guardian as well, or maybe they have a detailed power of attorney that gives them that ability. It was only in 2016 that we changed the law and finally allowed that disabled but mentally competent person to do it on his own. Believe it or not, before 2016, everybody else could create it that I just listed in that grouping, but the person couldn't do it on his own. So that was a great change. The second statutory requirement is that person has to be disabled. That is an absolute requirement to have this kind of special needs trust. The third requirement, it's got to be irrevocable. Can't be changed or else the assets are available, which defeats the whole purpose. And then yes, then the benefits would be at risk. The fourth statutory requirement, which is also often a downfall for people that are trying to do things without seeking the right kind of help. It has to be for the sole benefit of the disabled beneficiary. You can't have 3 kids and say, well, it's going to be just as well. I'll do one trust and I'll have sub-trust. That will not work. This trust has to only have the disabled beneficiary as the benefit for the trust. The fifth one have to be under the age of 65. Now, if the trust was established prior to the beneficiary attaining age 65, you can continue to qualify even after they attain age 65, but you can't continue to make additions to the trust after that point in time. Now, here's the one downside perhaps to putting a lot of money in a trust. There's a payback provision. So if these assets in the trust are not used for the benefit of the beneficiary during his lifetime, and so there's a substantial amount still left when that person dies, Medicaid will be paid back from those remaining trust funds for the benefits that were paid. And the other thing to please note, this is the first thing that happens. So if you're thinking, well, this special needs trust has money in it, so when this disabled person dies, we'll pay for the funeral. No, that will not happen because Medicaid gets paid back first. So a simple solution All you have to do is make sure you prepay for the funeral from the special needs trust before the person dies. It's a matter of timing though, and it can be critical. I already referred to this. These are a couple of reasons that often we find these trusts are created. The person doesn't plan on getting money. They're disabled and they meet the resource limits, but suddenly they have some sort of a lump sum payment from an inheritance or a personal injury award or something similar. And so suddenly they have to act quickly to do something legitimately with the money, or their benefits will be discontinued. Now, third-party special needs trust. No Medicaid payback. So if I put a lot of money in a trust for my disabled son, I can provide in that trust if my son dies and there's still trust funds left, those will be paid to his two siblings because there's no right for Medicaid to come back and make a claim. Also, you don't have to be disabled on a third-party trust like this. And there could be multiple beneficiaries. So go back to my example that you could not do on a first party, you can do on a third party. So I could make one trust for the benefit of my 3 children, including one who happens to be disabled or maybe slightly impaired. Maybe I'm worried that they're going to be disabled because they have a condition. I can do it all in one trust. Now, again, though, has to be irrevocable. And for a beneficiary that's disabled in particular, you can't give them any rights to revoke or to demand the trust funds, because if they have the right to demand it, if they have the right to get to it, then it's an asset. And we've, again, defeated the whole purpose of what we're doing. You can establish these trusts during your lifetime, or sometimes what we'll do in somebody's will or a trust, we'll provide that this trust is going to be established when they pass away, and it might already be set up as a sub-trust of their living trust. Now, what other options do you have? And remember, I referenced that age 65. And as you may or may not suspect, sometimes we create these trusts for people that perhaps are in assisted living or might be anticipating a nursing home entry. Well, they're past 65. What do we do? A pooled special needs trust is an answer. It's established and maintained by a nonprofit association. And what happens is you have a sub-account within that pooled trust that contains these assets that have been distributed to benefit the individual. Again, let's go back to how it's established. The guardian, parent or grandparent, the court, the beneficiary, or the attorney, in fact, acting under a power of attorney. Now, before I get to the payback provision, powers of attorney, you can find them all over the internet. Financial powers of attorney, you're not going to find a really good one on the internet, because the power of attorney has to have very express language and provisions that specifically authorize your agent to establish a pooled trust on your behalf. And if it does not, you don't have the authority. So now you're facing perhaps a court action, something much more involved. General advice, maybe the best advice you get out of this presentation: for financial powers of attorney, take the time, seek out proper legal counsel, get it properly drafted. It will save you so many headaches and issues later. Now, there's a similar payback provision, except if the estate recovery claim exceeds what's left in the trust, then the trust funds can be retained by that nonprofit organization in its charitable fund. Now, What happens then is if I have a trust that is a pooled trust and I run out of money, this retained fund that has been built up by these types of circumstances might have funds that the pooled trust can allow access to pay for my benefits, to pay for things I might need. Maybe I need a new chair, maybe I need a new wheelchair. So it's a great system in Wisconsin, and I'm going to talk about our trust in a minute. We have two great organizations that have a good retained fund that often provides for those types of benefits when somebody's trust becomes depleted. Now, for the pooled trust, you do have to satisfy that definition of disabled. So remember, even if it's a third party, you still have to establish the disabled. It's a little different than if you created your own third-party trust. I reference these. We have WISPACT and we have Life Navigators. And if you have a family member that you have been considering such a trust, I encourage you to go to their websites. You can call them. You can speak to a representative who can also answer other questions that you might have. But they're two wonderful organizations. And what they do, if somebody is on SSI and you're thinking you're going to create your own trust, and your brother is a smart guy, so you're going to have him manage it. SSI provisions are extremely complicated, and you can innocently make a distribution from a trust that might disqualify that person from SSI. One of the advantages of these organizations is you have a professional who understands those laws, who makes sure that inadvertently something like that doesn't happen. They also can assist in bill payment. They can expedite emergency distributions. You can have a trust advisor. So maybe I'm setting up this pooled trust for my youngest son, and I know I'm going to pass away at some point. My son's going to hopefully live a lot longer. Well, maybe I'll have his brother be the future advisor. So that when I'm gone, the brother can be the one communicating with WISPACT, indicating what the needs are and what the circumstances are. Sometimes a client will have a fear, well, will my disabled beneficiary really be able to get the benefit of this? Or are they going to deny his request? Is he going to ask for money and constantly be told no? My experience is that simply does not happen. If it's a legitimate expense, and it could be any number of things, and I think we're going to look at some of those in a second, that request is going to be granted. Life Navigators, that was founded by parents who were committed to developing programs and educational opportunities for their children that had intellectual and developmental disabilities. And they envision that inclusive community that includes those disabled individuals. They offer a lot of hands-on help, a lot of personal help. I didn't mention, on the other slide, you could always go back and see the institution that manages the money. For Life Navigators, it's Prairie Trust, which is a trust company located in Waukesha. As I mentioned before, the key is these trusts are not counted as available resources for the purposes of that beneficiary's eligibility for all of these mean-tested programs. A special needs trust will often specify the trustee is not obligated to and cannot be compelled by anyone to use the assets of the trust. It has to be total discretion. If it's not total discretion, there's the argument that the beneficiary may have access through some other means, which means it's a countable resource, which means we've created a lot of problems instead of solutions. Now, these are just some examples, but these trusts can pay for internet, it can pay for cable TV, it can buy a new tablet, it can pay for care managers, personal services, housekeeping, dry cleaning, attendants, companions. It's so broad. People are shocked at how much the beneficiary can truly benefit and enhance their life from these trust funds. Quality of life, appropriate vacations, appliances, tickets to recreational, Bucks, Brewers, all of those good things can benefit that person's life. Typically, you say it will supplement but not replace any of those public benefits. However, a trustee is also given the latitude of opting out. Sometimes, if you make a certain kind of distribution, it will decrease the beneficiary's SSI benefit. But if there is a sufficient trust fund, it may be worth it to benefit the beneficiary by making the distribution, even though that benefit is decreased. So I don't think you always want to make it an absolute. Under no circumstances can you make a distribution that might affect it, because there may be a time where a distribution outweighs the benefit of that slight decrease in an SSI benefit. Most importantly, no matter who you talk to, make sure they do this kind of work. In general, there's a lot of resources out there where the public can verify. Certainly with attorneys that practice in this area. Most of us belong to the National Academy of Elder Law Attorneys. And then Wisconsin, as many states, have a Wisconsin chapter of that National Academy. The State Bar of Wisconsin, as most state bars, have elder law sections that attorneys belong to. Be a good advocate, be a good consumer. I am never offended by people asking me how long have I been doing this and how much of a percentage of my practice it is. Just make sure you get adequate professional advice.
All right, thank you, Terry. That was really incredibly informative. And I know when I read your presentation before, I found myself really immersed in understanding the pooled special need trust matter, which I really was not aware of, and the WISPAC and the Life Navigators. I wonder how many people really know about that type of service. And I also wanted to know from you, since our audience is really national audience, are there similar type of services available in other states?
Yes, and I'll brag a little bit. I think Wisconsin is fortunate that I think we have one of the best pooled trust opportunities in the country, but there are many of these opportunities in almost all states, if not every state.
Okay, and how would someone access that information?
It's pretty easy to find if your state has it and you simply want to, again, I hate to say Google, but you can either Google Pooled Community Special Needs Trust or go to the National Academy of Elder Law website. And they have attorney listings for all 50 states. They have different resources. That's probably your next best bet, in addition to the State Bar Association elder law committees.
Okay. Now, and excuse me for not really having a probably clear understanding of this. Can someone have the pooled special need trust and a third party trust?
Yes, and sometimes that happens. Sometimes we have had people that want to kind of dip their toe in the water. They're listening to what I say about the pooled trust, but they really want to see how it works. And so we'll encourage a parent, well, why don't you start one now during your lifetime? You don't have to fund it with a lot of money, and then see how they operate. But in the meantime, they've got a third-party trust set up that they still might have a son or daughter operate. So yes, you can have more than one.
You can. And then the assets within the pooled special need trust. Now, some of that asset is provided by the family of that individual. But do I understand that some of it comes from the community as well?
Well, it comes from those people. So let's say my son passes away and he has $50,000 left in his special needs trust. And let's assume it's a first party. So the Medicaid payback is 70,000. It's more than the trust assets. So believe it or not, that 50,000 will stay with the pooled community trust in their charitable or retained fund. And that can benefit beneficiaries who perhaps deplete their trust funds during their lifetime, but they still have a need. They can request a distribution from that retained fund.
I see. So everybody benefits.
Yes, yes. And you get a professional administrator. And it's if I pick out one program, Adel, it's SSI that I'm most concerned with a non-professional managing. The advantage with a pooled trust is that you get that professional manager.
I got it. Yeah. I have a question about mental health issues. And as you know, we see a lot more of that. And, we're at a mental health foundation, and we know, you and I know how prevalent that has become, and increasingly so. Schizophrenia, bipolar, other very disabling mental illnesses, and also, a lot of what kids are experiencing with autism and things like that. Now, how is that governed? Since we really don't have a physical handicap that we can actually say.
If it is a mental disability, and again, you may have to jump through some guidelines to make sure that's established, that alone can provide the basis for a special needs trust.
Okay.
And a lot of these trusts are, I'm
Do you
sorry.
have to have any special directive within those type of trusts when you're addressing mental health issues, other than you would?
Certainly some of that compulsive behavior, for a private, especially if you're drafting it as a standalone trust. So let's back off of the pooled trust for a second. I want to spell out what the problems are, because everybody might have a different issue with how they handle money, their responsibility with money. And you want to alert anyone who might step in as a trustee, frankly, what to be on the lookout for, because that behavior can be destructive.
Yeah, I agree.
But yes, certainly. And I'm glad you asked that question, because if I wasn't clear, these trusts can be for anyone with a physical or a mental or a combination of disabilities. And they can be a great benefit. It is so sad when I see that, when somebody comes in and I find out they left money to a sibling, they gave them an extra share and they're going to take care. There's so many ways that goes wrong. And these are such simple solutions to that problem.
I totally agree. So thank you, Terry, very much. I
Thanks
really
for the
appreciate it.
opportunity.
This has been a great presentation. I've learned a lot. I hope all of you have learned from it. I thank all of you for listening to our podcast today with Attorney Terry Campbell. I also want to remind you that our foundation really relies heavily on your support and your help. You can always reach us at www.abkf.org or at obkorkorfoundation.org. We'd love to have your support. We thank you very much for being part of our journey, and thank you so much, and hope to see you on the road very soon during the 550/50 and other activities that we have. Thank you so much, and have a great day.